My name is Marcus Gehring. I'm directing the Center for European Legal Studies here at the University of Cambridge. And this week we have another one of our lunchtime lectures, which we're going to conduct in hybrid format. So we have an audience here in the law faculty itself and participants online. It's my real personal pleasure to welcome Professor Dimitry Kochenov, who is a professor in the Department of Law of the Central European University. He's a renowned author and sometimes referred to somewhat cheekily as the Passport Professor. I know him well from his time at the University of Groningen, where he worked for many years. He is a world-class expert on citizenship, passport. His Passport Index is one of the leading publications in the field. More recently, he's also distinguished himself in the rule of law literature, where he has made significant contributions on the challenges in the rule of law that some member states of the European Union face. Today, he's going to talk to us about Passport Apartheid. And I'm personally quite excited as someone whose children have 5 passports. I'm always excited to hear what the latest in citizenship law and passport is all about. Dimitry, it's a pleasure to have you in Cambridge and finally in person.
It's my absolute delight, really, to open this post-pandemic phase in our lives with something that will excite at least those whose children have 5 passports. But my main preoccupation today is actually trying to rethink EU law from the perspective of the constant attention to personhood that this legal system awards. So I would like to provide an alternative view, as it were, which I hope will be useful to some, on what the European Union is about. And this alternative view could be hypothesized as Etienne Balibar versus Sir Francis Jacobs. Because we all know the first writings on personhood in EU law, at least those who follow the field a little bit. And the EU rightly prizes itself and is also highly regarded for protecting the individual. So the whole idea of free movement of persons, the whole idea of respecting fundamental freedoms, which come as a super bonus for those who fall within the scope of EU law, is one of the jewels in the crown of EU law and one of the main achievements of the EU. This is one perspective, and this perspective goes back most importantly to the collection that Sir Francis edited in the beginning of the 70s, which was called EU Law and the Individual, a spectacular contribution to EU law. And there is a conflicting perspective, and that conflicting perspective also deserves to be taken very seriously, and that's Etienne Balibar, a sociologist, of course, but a sociologist deeply engaged with the law of the Union and with the destiny of Europe as a common project. So Etienne Balibar, in his Nous les citoyens de l'Europe, writes of the EU as an apartheid regime that unfortunately stands out among all the other institutional systems around the world as far as the treatment of the individual goes. So in my talk today, I will try to walk you through the core elements of these of the space between the two perspectives, and show how the Bolivarian perspective could be closer to the truth. rather than the perspective that Sir Francis provided us with. So the EU is kind to individual. We know this from the very beginning. The fundamental freedoms push EU law beyond what any other legal system has guaranteed, precisely because, in the words of Gareth Davis, the EU is about humiliating the member states. Why would anyone humiliate the member states? Simply because this legal system is there on the side of the individual who can invoke the supranational law in any kind of conflict with public power. And here, of course, Gareth Davis analyzes this tongue-in-cheek, as it were, because for Gareth Davis, the fundamental starting point is that, unfortunately or fortunately, the supranational system of law that the EU has created allows individuals who invoke EU law smartly to set aside lawful and legitimate outcomes of national democratic process. So what the EU does to the individual is empowering some in the context where that empowerment de facto means that national law and national democracy is something that they should not be concerned with in organizing their lives. This is called supremacy of EU law and free movement of persons in the context of non-discrimination on the basis of nationality. So I actually came to EU law precisely because I love this perspective so much. Not being a statist, I found added value in all the writings that demonstrate how a person can actually tame public power, no matter how legitimate on the face of it that public power claims itself to be, and gain some rights against the omnipowerful authorities. So this is what the EU is good at. And at the same time, once we look at the essential characteristics of this constitutional system that the European Union has created, what comes to mind immediately is that the distinction between this supranational constitutional system and any other constitutional system in the world is drastic. And it's drastic precisely because it's the only personal constitutional system. And this is where, once we really make an emphasis on personal, this is where plenty of possible criticisms spring to mind. And this works at different levels. At the most commented on level in EU law, personal means that you personally need to fall within the scope of EU law once you satisfy the basic citizenship requirement. So as an EU citizen claiming an ability to move from state A to state B, both member states, of course, you are supposed to prove that there are some instances in your biography, in your CV, in your studies, in what you actually are engaged with professionally, that would be considered by the Court of Justice as relevant in order to activate you in this cross-border setting, in order to apply EU law to you. Or you should find yourself in a situation which is deeply dangerous in terms of potentially resulting in the annulment of the very status of your citizenship that you enjoy. So I called it the law of personal circumstances in Europe. What does the law of personal circumstances mean for EU citizens? It means that there is actually no equality before the law. And the best analysis of that is provided by Sasha Somik, of course, who is at Vienna, who, with a tint of provocation, tells us that the main principle of EU law, and this is his last book, which Hart published, the main principle of EU law is that the law is never known to us, which means that no other legal system, at least not officially, at least not not in such an overt way, would actually demand of the judges at all the levels, in all the localities that this system applies to doubt whether they understand the law and to doubt whether they can apply the law correctly. And this is the preliminary ruling procedure. So the preliminary ruling procedure means that the starting point of our understanding of EU law is that we don't possibly, or it's quite possible, and it's quite probable that we don't know the law. We always have to ask questions. And it's not only knowledge or the lack of knowledge of the law that is a characteristic of the system. It's also the lack of knowledge of the scope of the law, which is fundamentally important. Because the court will look in each particular case at what kind of a family situation, what kind of education situation, what kind of a house situation, etc., 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 the rights of children, what kind of a personal situation the person finds herself in or himself in. And it means that the general lack of knowledge about the law, when it's fused together with the general lack of knowledge about the scope of the law, creates a situation where the law is A, unpredictable for many, and B, lacks the generality of its application. Of course, you might say it's twisted logic. This is how the member states designed the system to work. Fair enough. And we have a lot of wonderful literature trying to justify it. And it's usually justified by the recourse to market citizenship, so-called. So the EU is about market citizens. Market citizens are the guys who get protected by EU law, including against their own member states. And then all the other EU citizens are simply not good enough to be protected. So this is the framing which is synonymous to what I have presented just now, but it's somehow framed more positively in the context of the internal market literature. Actually, plenty of scholars, renowned scholars of EU law, adopted this perspective. My favorite criticism of this perspective comes from Charlotte O'Brien, who demonstrates how flawed it is to single out some ephemeral market citizens out of the body of citizenry of the European Union in order precisely to deny any protection under EU law, either via the framing of the scope of the law or via the framing of the rights of citizens under EU law to all those who are not considered as market citizens. So the law that we end up having on this perspective, and I'm only speaking about the privileged now, those who are EU citizens according to the formal status that they hold, the law is absolutely unknown and the law is punishing for those who need protection. So in a small chapter, which I wrote in a collection in honor of Professor Lawrence Gormley, I called this the oxymoron of market citizenship. What is the oxymoron? Usually we deploy citizenship and fundamental rights in any constitutional setting in order to protect those who we consider belong to our people, to our citizenry, from the adverse effects of the market forces or simply of whatever adverse forces that they experience in their lives. This is the essence of public law on this positive reading. Of course, it's not Putin's public law in Eastern Ukraine, it's our public law, which tries to protect the individual. But market citizenship means that you protect the market against the individual. And if there are any individual claims against the market under the law, then they have to fall into the cracks between the planks of this legal flaw. They have to be disregarded as illegitimate or as coming from someone who doesn't qualify. And all those who need protection won't qualify. This is what Charlotte O'Brien demonstrates with clarity. But this is only the start of the story. This is the elitist start. In fact, the interesting point about the EU law is that it doesn't actually exist for all those who don't formally qualify as EU citizens. And this is where I come to astonishing differences between EU law and any other constitutional system on the globe. The first quite significant difference being that the market is protected against the citizens, and the market, I use it in the internal market sense, not really in the Marxian sense, because what I describe is based pretty much on the case law, not on the philosophical reading of the term. So the first astonishing difference is that the citizens are due to disappear in the eyes of the law if they need to be helped. And the second, much more significant difference, once again, is that if you are not a citizen of the union, then the union legal system disappears as such in the absolute majority of cases. So if you are an Indian in Estonia, if you're an American in Germany, if you are a South African in the Netherlands, then EU law will not help you because it doesn't exist for you. And we got used to this, but I think it's very much a pity. Because if you look at any other constitutional system, the law actually applies equally to all those in the territory and would not claim that not having the citizenship of that particular territory in the eyes of the law of the territory would entirely disqualify you from the ability actually to see the cathedral. EU law is no more once you lost the EU citizenship. So for those Indians, for those Russians, for those Americans, the internal market disappears in thin air. All the borders which has been officially eliminated for the use or abuse by EU citizens, they suddenly are impenetrable. All the documents that open borders suddenly become the documents that distinguish you and make you in any way incomparable in the eyes of the local authorities, the authorities of your member state, as well as supranational authorities with those who hold the status of EU citizenship. This means just one thing. It's an apartheid system, I repeat Baribach, in the sense that only the personal scope of the law matters as far as the very existence of the law of the internal market, which would apply to non-citizens, goes. It's not like this in Russia, it's not like this in India, it's not like this in the US, because the whole system only being anchored to the distribution of the statuses of citizenship, this is quite rare. In this sense, it's probably similar to some kind of ancient charters of aristocracy or nobility, or the statuses of allowing one to dwell in a particular city, Catholic Church, or being visible or invisible in the eyes of the church. So if you think about how pre-modern or early modern early empires were organized, and think about the stratification of the populations based on faith, indeed based on skin color and other characteristics, arbitrary characteristics, you will find exactly the same. So for instance, if you are a Jewish resident of the Russian Empire, the very geography of your possible settlement was significantly limited. And every map of the empire would mention, this is the place where Jews are allowed to live. They cannot step over the invisible border. Some Catholic residents of the empire will have, and subjects of the empire will have different rights, and then Orthodox subjects of the empire still more rights, while the worst would be the Muslims and those who don't believe in Jesus Christ, or those who go into non-Abrahamic religions. They will have no rights too. And there will be internal borders where the documents of these third-rate citizens will be checked. So this is what the EU emulates. The EU is a public law system which is grounded in personhood statuses that the EU distributes. And in this sense, it's a very bizarre system because it doesn't only disappear in the eyes of those who don't have those statuses, it also fails to help those who are not good enough to qualify in full as market citizens. So already here we see plenty of problems that arise from this absolute preference which is given to the idea of the legal status, which is put on the high pedestal in the system of EU law. But once we look at how the non-citizens in trouble are treated in the EU, this curve of injustice is even steeper. So we started with the EU citizens who fall between the cracks of the understanding of market citizenship. They don't derive any kind of protections of EU law. Then we move to the third country nationals in the EU for whom the whole legal system disappears. And now once we move to those who have applied to enter the territory of the Union, that's where the Union actively engages in, let's call it criminal, but not in the eyes of criminal law probably. We still call it criminal acts because the Union tries to kill them. And this is something that goes much further than the mistreatment of those third country nationals who are in. I advise everybody to read the New Yorker article, which was published, I think, in the early December issue by Ian Urbina, who investigated the funding that the EU Emergency Trust Fund for Africa allocates to all kinds of thugs around the African continent in order to reduce mobility around the African continent under the pretext that it's better to lock people inside particular territories, and B, in order to make sure that instead of being saved and treated fairly by being given access to rights once these people reach EU shores, they are kidnapped and then kept in prisons indefinitely and then sold for ransom when their families have enough money to pay. So unfortunately, and I say it with deep regret, as a citizen of the European Union, we are all responsible for the system of mass torture and occasional killings, which the EU has financed from our pocket and established mostly in the Libyan territory, what used to be the Libyan state, but also elsewhere. And over the last years, what Urbina cites, and the data is confirmed, widely 80,000 people went through this torture machine that the EU has established. So what is called search and rescue by the EU, in fact, is search and capture, which ends up with the delivery to migrant jails, and which function under Libyan law, so-called, and are fully funded by EU money, where people can be held indefinitely, because there is no notion of rights for those people, even though they haven't committed any crime. But the Mediterranean is one thing, and the Białowieża forest, that UNESCO protected forest that separates Poland and Belarus, is another, because this is where the EU, via Lithuanian border guards, via Polish border guards, with the help of other member states, the Danes sending in barbed wire, Frontex sending intelligence, just like they do with the thugs in Libya, who ride EU-financed boats and who fire at NGO ships trying to save the migrants from the sea. There, the police pushes children into the forest in full knowledge that most likely those guys will actually die. So when I say that the EU kills, it's not a hyperbole of some sort. It's a factual statement. And then as EU citizens, we need to think about how to create a system in EU law which would actually make someone accountable for these killings. Because for now, this Trust Fund for Africa and then the use of Frontex, it's trillions of euros. The Trust Fund, Ian Urbina cites 5 billion going through it. I checked the latest report that the fund received, that the fund released. 3.5 billion has already been used, mostly in Africa. And what they have produced is a torture machinery of new borders and indefinite detention. What the New Yorker underlines and what no European newspapers write about, or almost none, the Guardian had something, but the Guardian is not in the EU anymore, is that unfortunately there is no accountability at all for how this money is invested and what it is actually used for in practice. So, the Commission's agencies, the guys who run the fund, they always tell us we only want to do good. We only want to create orderly systems of migration. So our goal is not the torture chambers and is not drowning people, but just to help create a system when those people don't come to Europe, in fact. And then once you look at what journalists do and the information that they managed to uncover, it's absolutely clear that this Libyan border guard, or coastal guard, so-called, which is an EU-created thug militia that kidnaps people from the sea and prevents those who want to save those people from reaching to the boats, get direct intelligence from Frontex. So we pay the Frontex drone to help imprison people indefinitely in some places which exist out with the law. So when we speak about the EU and personhood in the EU and the system of passport apartheid, where only the Burgundy passport counts, even to see the legal system, we should also be able to take full account of the fact that we are part as citizens, as long as we believe that the EU is a democracy, of this machinery of killing people. And people are killed for one very simple reason. If citizenship is about blood, and that's indeed the case, the EU being the global aristocracy, because if we just look at the quality of different legal statuses around the world, it would be absurd to claim that any passports from Africa, especially sub-Saharan Africa, but it doesn't really matter, would compare in terms of the rights they grant with any of the documents issued by an EU member state. This is a natural divide in the world, or it's presented to us as natural. Well, in fact, it's absolutely abnormal and it's racist, because all those guys don't look like President von der Leyen, under whose watchful guidance billions are spent in order to put people in jail for life, just for attempting to reach the zone of prosperity, especially in their eyes, which the EU actually is. And we have amazing research by now on the role that citizenship plays in global inequalities. Especially Professor Branko Milanovic has done amazing work on this. By now 2 books which are of direct relevance. And what Branko Milanovic teaches us, and he backs his claim by numbers, is that over the last 100 years, global inequalities have shifted from inequalities based on class to inequalities based on space. So as long as citizenship as a status was designed in order to get us rid of class inequalities by simply treating a count in the same way as a peasant would be treated, by claiming that both belong to the people and both should be entitled to, at least to some degree, at least at the verbal level, to the same rights and comparable duties, all this doesn't work, or works ingloriously indeed, once inequalities are based on space, because the main and the only right of citizenship in the world today is the right of access. It's whether you can pass the border or not. And only the borders between the have-nots, or the spaces of have-nots, and the spaces of the haves, the borders between the global aristocracy and the global other matter. And in this sense, the only role that citizenship plays today at the global level is precisely that one. It's the instrument of entrenching and normalizing global inequalities and making sure that people cannot upgrade their socioeconomic status vis-a-vis the environment to which they got born. So since only 2% of the world, the UN tells us, migrate up to the point of changing citizenship throughout their lifetime, we're speaking about blood aristocracy. And the blood aristocrats are us. And this aristocracy has a huge cost. And that huge cost is clearly visible in the bodies of those who are not aristocracy and who are being washed ashore on Malta, in the Greek islands, Italian islands, etc., etc., etc. So the EU rejoices in this blood aristocracy by trying to debase any kind of claims that the world is not actually just, the world which was co-created by the former colonizers acting together. So the EU, of course, played a part, but was not the only one who created contemporary world. But what we come down to is that, in fact, the global world system as it functions today is about the myth of equality of states, which sovereign equality of states, which translates into the preached equality between citizenships, in full knowledge that this is indeed not the case at all. So all the idea of guarding the borders and keeping those who don't belong out in the EU and elsewhere translates into one simple fact, which is at the base of global immigration management today. That simple fact is global aristocracy, the super citizens of the global West, are ready to kill and invest unlimited amounts into making sure that the world order is not changed. So plenty of questions arise in this respect, how the EU can become different in order to stop killing the racialized other, or at least to start bringing those who are responsible for this, strictly speaking, application of our law to justice. And it's difficult to think where to start, because unfortunately, it's precisely the normalization of overwhelming privilege, which is based on the blood lineage given status, that is the base of the legal system in Europe. So if we round up this circle and go to the point where we started, that EU system only exists for those who have the formal status, then there is only a small step between not seeing the other at all and dismissing any claims of those people who spent years in EU-funded jails in the territory where the very idea of the law doesn't exist. And then what is the role of the Court of Justice in this whole system? Unfortunately, the court has not been powerful enough in the current context of interinstitutional balance to defend the basic right to life. Because the starting point and the starting alarm bell was what the court said about the deal with Turkey. We know how the deal with Turkey works, but in the eyes of the court, unfortunately, this is not law. But well, all the application of EU law is not law, because if we are honest in reading Sasha Somik seriously, the starting point of law would be equality before the law and equal application of rights and duties to all those who happen to be in the territory of a particular constitutional system. But this is not the starting point of how the EU was founded and how it functions. And to finish with the last case of this pushbacks in Greece, which is particularly interesting and is now in front of the European Court of Human Rights, involved a French lady who was persecuted in Turkey under some absolutely, in the horrible circumstances post-coup attempt over there. She already had a prison sentence hanging above her as a sword. So she decides to escape via this illegal route. An EU citizen traveling illegally with the illegal migrants from the country with which we have this wonderful deal, which is actually not law and which is not to be scrutinized by the Court of Justice. She shows her French passport and the French ID, and she's pushed back into the rubber boat and tagged back to Turkey by the Greek border guards, because she was in the company of the wrong people. The EU is not created to uphold the interests of anyone in the rubber boat, even if it's a French lawyer, a French woman. She's serving a 6-year sentence now in Turkey as a result of this pushback. It's terrible what happened, but I'm happy for her that she's alive, because many people don't make it. And we shouldn't play as if this is something exceptional, and we shouldn't play as if we don't know. So to finish, just a simple statement. Yes, from the internal market and the way how the internal market is organized to the Mediterranean and to the Belarusian forest, where children are pushed back to die, the EU is a system of passport apartheid, which unfortunately is designed only in the interests of the global aristocracy of those for whom the system exists at all. While for all the rest, Etienne Balibar is absolutely right. Thank you very much.